561A of the Criminal Procedure
जी
Code.
लॉर्डशिप वो
If you can first read it.
जी इनहेरेंट पावर्स तो हैं
So,
there's a specific provision.
Salman, all the provisions of the CRPC are subject to 561.
वो तो होती है
Salman sir,
please.
sorry, for my
जी
understanding,
सर प्लीज सर
this appeal has been filed under subsection 3 of section 12 of the Criminal Law Amendment Special Court Act 1976.
सर
How does the Criminal Procedure Code is attracted in case of this appeal?
मैं आज कर
Because the special law does
मैं
not
आज
say
कर
so.
Your Lordship, I was anticipating that question and I have come prepared on that point. मैं असिस्ट करता हूँ सर. So kindly see, पहली बात तो ये है, Section 431 refers to all appeals. Section 431 on two occasions refers to law to death. Death has been explained in the law of abatement. इस सेक्शन में 417 का भी जिक्र है which is appeal against acquittal कि वो भी अबेट हो जाएगी. जो जिस सेक्शन की तरफ जनाब इंडिकेट कर रहे हैं, प्रेफर कर रहे हैं 12(3), वो है any party who is aggrieved from the final order or judgment of the special court. So it could be an appeal against conviction, it could be appeal against acquittal.
I think the question is whether it's Criminal Procedure Code applies to that tribunal.
Your Lordship. Number one, sir, definitions में section 2A
When it comes to
CRPC applies.
Special law.
Special law. Sir,
Section-
first of all, I would refer to 2A.
Section 13 पढ़ लीजिए.
मैं 13 पढ़ लेता हूँ. ये जी ओवरराइडिंग इफेक्ट है सर. लॉर्डशिप, आपकी इजाजत से इससे पहले 12(3) में जिसमें अपील है, एनी पार्टी एग्रीव्ड बाय द फाइनल जजमेंट of the special court may prefer an appeal to the Supreme Court within 30 days of the passing of the
So
judgment.
now this appeal has not been filed under any provision of the Criminal Procedure.
It has been, sir. मैं अब यही justify
It
करता
has
हूँ
been filed
कि वो
under this
वो
special
कैसे.
law.
Your Lordship, this is
पहले 13 जरा पढ़ लीजिए.
जी 13, sir. The provision of this act shall have effect notwithstanding anything contained in the Code, the Evidence Act 1872, or any other law for the time being in force overriding effect. Now, Your Lordship, my submissions for to satisfy my Lord on that query would be, number one, this is not an appeal under section 185. This is a direct appeal to the Supreme Court for the first time. This is a case of first impression. Never before anyone has been tried for high treason. And this law has been very rarely put into use. Very rarely. There are no reported judgments of this special law. Section 2A of the law, the opening lines, code to govern the proceedings is CRPC 2A. Then the entire case, 87 हुआ, 88 हुआ, 265K हुआ, 512 हुआ, 514 हुआ, 342 हुआ, वो सब का सब यहाँ रेगुलेट हुआ.
दूसरा ये भी है कि जो 13 to my reading of 13 is that if there's any provision in this act which is inconsistent with the code,
Inconsistent.
then code will not apply.
So,
But
मैंने उसको उस एस्पेक्ट को भी Your Lordship देख लिया.
Yeah, this is the one and only trial ever taken place pursuant to this law.
In Pakistan, sir.
Naturally, all
Yes.
there is.
कहीं और तो नहीं लगता ये law.
Yes, sir. This is a case of first impression or
And now can you come to the 561A, unless you have to say more on this?
Your Lordship, मैं इसको conclude कर देता हूँ कि इसमें अगर कोई मेरे पास और एक तो I would like to refer to the definition of abatement in blacks.
आपने जो बात अर्ज की, आपने कहा कोड अगर इससे तसादुम रखता है तो ये लॉ प्रिवेल करेगा, अदरवाइज कोड के प्रोविजंस
मगर
एप्लीकेबल
जितनी
हैं.
रिपोर्टेड जजमेंट्स हैं टेररिज्म पे, नैब की, एंटी करप्शन की, स्पेशल कोर्ट्स की, जितनी हैं, द प्रिंसिपल इज विद डेथ. The corporal punishment, monetary nahi hai sir, are exacted from the body. The body is no more the appeal will abate, it will not continue. Continuance is a possibility if family steps in through Supreme Court rules, through a formal application, that too. आज सर family आ भी जाती. The law of the country does not permit the family. This is my speaking for myself. Unless my lords would permit them, stigma ground पर. Fine नहीं है. जब फाइन नहीं है तो फैमिली आ भी जाए.
नहीं वो हम देखिए हम दरवाजा बंद नहीं करना चाहते हैं. हम उधर आज हमें ऐसा देखिए एक बुनियादी असूल ये होता है तो मफरूजों के बेसिस पे आप फैसले ना करें.
जी सर. तो
कल किसी की राइट चली जाए और वो कहेंगे जी आपने तो अपने आप पे ये एक्चुअल कोई आएगा लीगल है वो शायद ये पॉइंट रेज करे तो हम इसको दरवाज़ा बंद नहीं करना चाहते हैं. ये तो आपको वाज़ेह तौर पे कर दें. मगर मैं सिर्फ वजाहत के लिए आपसे पूछ रहा हूँ 561A में अगर हम दरवाज़ा खोलना चाहते तो वही लीगल अर्ज खोलते हैं मगर हम 561A का सहारा लेकर के शायद खोल सकते या नहीं खोल सकते. ऐसी आपकी सिंस आप मौजूद हैं और माशाल्लाह काफी महारत है क्रिमिनल लॉ में इसलिए हम आपका प्रेजेंस का फायदा उठा रहे हैं. प्योरली एकेडमिक.
I must confess this was the most difficult brief that I have handled so far. High treason इससे पहले कभी ऐसा था नहीं. आप यहाँ से अंदाजा लगा लें सर. It came to me as a surprise. There were as many as 21 prosecutors appointed to bring home the guilt of the appellant and I was the only one defending him and that too जो मेरा एक गिला था.
गिला
जी योर लॉर्डशिप था.
ये तो फिर आप आपका तस्दीक कर रहे हैं कि I'm equal to 21.
Your lordship, even I was ousted from the proceedings और वो then I had to go to the Islamabad High Court.
चले वो छोड़ें ये पॉइंट
to my rescue और मुझे
वो सुनते बाद में मगर ये पॉइंट बताइए.
Your lordship 561 आपने
जी
कहा कि मैं वो
10A पे खड़े होते हैं.
नहीं 10A पे खड़े होते हैं 561 पे खड़े होते हैं ऐसी.
लॉर्डशिप ये तो हम अगर वो शुरू करेंगे तो ऑफ कोर्स एक नई विंडो खोलनी पड़ेगी और उसके लिए if my lords are inclined
नहीं
that would only be if the legal aids had come and they had challenged the violations.
अगर कोई आता तो हम खोले ना.
लॉर्डशिप अब वो कहना मुनासिब तो नहीं है because I already appreciate the steps this honorable court has already taken. The legal aids are not in the country.
नहीं वो हमें उनको पता चल गया. अच्छा एक सवाल मैं अगर आपसे पूछूं you said you had very grave reservations about the Lahore High Court. What were the grave reservations about the Lahore High Court?
Your lordship,
I do not even appear in.
Your lordship, I was assisting. My engagement was to the extent of.
ऐसी पूछ रहा हूँ. सिटी में आपने बहुत ही बिल्कुल.
उसके बाद वो तो लॉर्डशिप I am not before the honorable judge for many years, even in the Supreme Court of Pakistan.
Why?
So मैं पेश उनके पास.
You want to disclose or not?
I would not like to disclose. जनाब मुझे इन चेंबर पर्सन तलब करना चाहेंगे मैं एक्सप्लेनेशन.
नहीं हम चेंबर में नहीं बुलाते किसी को.
Shah Saab is aware, but for personal reasons, purely for personal reasons.
Shah Saab is aware.
Lordship, मेरी एक प्रिंसिपल पोजीशन भी थी, स्टैंड भी था. तो मैंने इन ऑल फेयरनेस मैंने उनको वो आर्ग्यू करना चाहते थे वो किया. बट और इन द मीनवाइल मैं ये भी एक्सप्लोर कर रहा था कि फैमिली मुझे देयर हैज टू बी अ फ्रेश एंगेजमेंट. मैं ये भी कहना चाहूंगा माय प्रोफेशनल ऑब्लिगेशन
टर्मिनेट्स ऑन डेथ ऑफ द वकालतनामा खत्म हो जाता है. कॉन्ट्रैक्ट खत्म हो जाता है, वकालतनामा खत्म हो जाता है. क्योंकि कल आके वो कह सकते हैं आपको किसने इजाजत दी.
इसने इजाजत.
ये लोगों को बुलाएं. ये
प्लीज सर
एक चीज बताइएगा related to this. You see, this was a case which was forced upon the federal government by this court, but they did not go back to 12th of October. Now, in the light of the amendments made in the Constitution, Article 270, AA, read with Article 12, is the door still open to proceed against those who collaborated in what had happened on 12th
Lordship, had I been given the mandate to argue the appeal, my opening grounds would have been that this is a case where a constitutional crime has been investigated and prosecuted in an unconstitutional manner. For the reason, the obvious, the visible, the aiders, the abettors, the collaborators, those who were involved in the consultation process were dishonestly, there was a let-off. All the members, ये नेशनल असेंबली में ये सारी की सारी इंडोर्समेंट्स हुई इसके ऊपर, प्राइम मिनिस्टर की इन्वॉल्वमेंट थी, लॉ मिनिस्टर की इन्वॉल्वमेंट थी, प्रोक्लेमेशन ऑफ इमरजेंसी के आप ऊपर देखें कि कौन कौन से लोग हैं जो इन्वॉल्व थे, इवन ऑनरेबल जजेस एज सेड बाय
myself have a different view. Were not been legalized, legitimized by this court, there would not have been 3rd of November.
Of course, sir.
But could 3rd of November have been directed, the federal government could have been directed to initiate from 3rd of November and leaving or ignoring 12th of October?
Your Lordship, this was actually attempted right before the decision of the special court. The old prosecution team was notified, denotified, and a new one was notified who stepped in and filed an application that this complaint has not been filed correctly. And there should be certain amendments and changes in the number of accused and allegations as well. But that application was not entertained, and in a haphazard manner, without recording 342, without listening to my submissions, closing speech, without leading defense evidence, a judgment was handed down, which was not a unanimous judgment. मगर ये अटेम्प्ट होने की कोशिश इस ट्रायल के अंदर भी हुई कि आप इन सारे ओवरऑल whoever was involved, इसका कैनवस बहुत वाइड था. Why target and narrow it down only to one person? This is repellent to common sense that these actions could have been taken single-handedly by one person without the advice of everyone.
नहीं तो खैर ये तो मफरूज़ों में जा रहे मगर ये तो उससे तो कोई बात नहीं होगी कि कलेक्टिविटी विल abolish the individual act.
वो है. It only points towards unfairness.
हम जरा 5 मिनट के लिए उठते हैं और शायद फिर आज ही सुना दें उन CPs में भी. उधर तो आपको कुछ नहीं कहना है ना, और इसमें भी ठीक है.
Thank you.